Hello, good evening, everyone. I am Anish and I welcome you all to today's session. As you all must know, we have started two series for CLAT aspirants where we will be covering the complete syllabus primarily for quantitative techniques and legal reasoning section. In the previous session, Ashutosh covered the basics of contracts, and in today's session, we'll be delving a little bit more into depth into the contract section for legal reasoning section. A little bit about Ashutosh. Ashutosh got an amazing All India rank of 10 in CLAT 2024, the recently conducted exam. He will be joining NLSIU in July this year, and he has a great grasp over the legal. He has a great grasp over the legal reasoning section, and that is evident from his scores in CLAT 2024 as well. So, pursuant to this, he will be the faculty for the legal reasoning Brahmastra that is started by National Law Training Institute NLTI. Over to you, Ashutosh. Let me know if you face any difficulty sharing the screen and all. Over to you.
Thank you so much for the introduction. So, hello everyone. I'm Ashutosh. I'm from Brahmastra, and as Anish introduced me, I secured CLAT All India Rank 10, and I'm here today to delve into the second half of Law of Contracts. I covered a lot of fundamentals in the last class, which was last Wednesday, and I'll give you a quick recap within 5 to 10 minutes of the past session, and then we'll move on to our next part. So, I'm going to share the screen now. Yeah, so I hope it's visible.
Yeah, it's visible.
All right. So as I said, we had started off with the basics. What exactly is a contract? So a contract is defined in technical terms according to the Indian Contract Act, that it is an agreement enforceable by law. But then we studied about what the building blocks of a contract exactly are. Firstly, competent parties. Secondly, lawful consideration and a lawful object. Thirdly, the consent must be free. Fourth, the agreement must not be something expressly declared to be void in law. So then एक example say I started to describe how a contract is made. So A B के पास जाता है एक offer देने के लिए, hoping that B will accept it. So A is proposing an offer or a proposal. जब B agree कर लेता है A के offer को, B is said to make an acceptance. So the proposal जब B ने accept कर लिया, ये एक promise establish करता है, और जो A और B एक दूसरे के लिए करने को राजी होता है, that is the consideration for the promise. What the set of such promises establishes is it is an agreement. So ये agreement contract बनने के लिए it must carry with it some legal obligation. It should be enforceable in law, and it should not be something that's merely social or moral. So then I talked about what a proposal or an offer is in depth, its definition, the essentials, a few cases related to it, and a few general terms like, for example, general offer क्या होता है जो public को करते हैं, specific offer to a definite person जो कि वो ही accept कर सकता है, counter offer जो कि एक proposal को थोड़ा accept करने से पहले modify कर लेते हैं, which actually is not a real contract. क्रॉस ऑफर दो पार्टीज एक दूसरे को इन इग्नोरेंस ऑफ द अदर ऑफर प्रपोज करते हैं सेम चीज. इम्प्लाइड ऑफर, एक्सप्रेस ऑफर एंड सो ऑन. देन वी टॉक्ड अबाउट एक्सेप्टेंस, जिसमें सबसे इंपॉर्टेंट पार्ट कवर किया था कि कम्युनिकेशन ऑफ प्रपोजल और कम्युनिकेशन ऑफ एक्सेप्टेंस कब कंप्लीट होता है, एंड अगेंस्ट द प्रपोजर एज वेल एज अगेंस्ट द एक्सेप्टर, जिसके ऊपर क्वेश्चंस भी सॉल्व किए थे. एंड वी टॉक्ड अबाउट रिवोकेशन ऑफ एन ऑफर, कब उसको वापस लिया जा सकता है. So we solved this question, which was from the past CLAT paper, the previous CLAT papers from 2020 onwards. And now we talked about validity of a contract, जो 4 factors बताए थे. Firstly, competence of parties, जहाँ पे age of majority होनी चाहिए, sound mind होना चाहिए, you should not be disqualified from contracting by any law. Secondly, lawful consideration, जो आप दे रहे हो वो lawful होना चाहिए, and lawful object, जिसके लिए we talked about exceptions like agreements जो कि restraint होता है marriage के, trade के, legal proceedings के, public policy और good morals के. All of these are agreements which are void because they do not have an lawful object. Now we talked about this paragraph as well, which came in CLAT 2022, if I'm not mistaken, जहाँ पे legal proceedings के restraint में agreements को void declare किया जाता है. नेक्स्ट फैक्टर इज फ्री कंसेंट, जो कि होना चाहिए. कंसेंट मतलब दो पार्टीज अग्री कर रहे हैं अपॉन द सेम थिंग इन द सेम सेंस. एंड अ फ्यू mediating factors like coercion, undue influence, fraud, and misrepresentation. Now keep in mind, all of this is not to be mugged up for CLAT because it's not required to that extent. But the importance of learning these is that you get acquainted to the legal terminology. And for example, a contract law का passage आ भी गया तो real exam में, so you will not have a lot of difficulty grasping what the concept is exactly about, right? And we talked about this, the fraud and misrepresentation passage as well. So today we are going to start from mistake. So what is exactly a mistake? It is an error on part of the parties जो कि वो agreement को either void कर लेता है या voidable कर लेता है. Like a mistake is something जो कि violate कर देता है वो principle को, which states that दोनों parties should agree upon the same thing in the same sense, consenting in an added sense. So mistakes कई प्रकार के हो सकते हैं. For example, as to the subject matter. So subject matter of the contract की तरफ जो mistake हो सकता है, it can be regarding its existence. How? Let's say A agree करता है B को एक TV sell करने के लिए. But unbeknownst to both of them, the TV which was agreed to be sold had already been destroyed before the date of contract, right? So वो exist नहीं करता, and that's why this agreement is void. Secondly, identity के regarding mistake. A promise करता है कि he will sell a car to B, right? बट वो जो कार बोल देता है, ए के पास तो दोनों कार है, एक ऑडी है और एक BMW है. सो अगर ए सोच रहा है कि मैं ये वाला बेचूं और बी सोच रहा है कि मैं ये वाला खरीदना चाहता हूं, सो देयर इज अ मिस्टेक रिगार्डिंग टू देयर आइडेंटिटी, राइट? नेक्स्ट इज रिगार्डिंग ओनरशिप. ए अग्री करता है बी को एक मोटरसाइकिल बेचने के लिए, जो कि बोथ बिलीव करते हैं दैट ए ओन्स इट, बट the fact is that वो मोटरसाइकिल एक्चुअली बी के नाम पे है. सो लाइक दिस इज अ मिस्टेक रिगार्डिंग टू द ओनरशिप, राइट? नेक्स्ट कमिंग टू रिगार्डिंग प्राइस. 500 लिखना था, 1500 लिख दिया. So this is a mistake and this voids the agreement. Next, regarding quantity or quality. So I'll take you to understand this through a case called Hankel versus Pope, right? So A agree करता है B को, मतलब inquire करता है कि I want to know the price of your rifles and I may buy as many as 50 rifles, right? सो बी भेजता है उसको अपना प्राइस और टेलीग्राम करता है, एंड देन बी बोलता है कि इतने राइफल्स हैं और वो एक्सेप्ट कर लेता है. लेकिन बात ये थी कि ए एक्चुअली वांटेड टू बाय जस्ट 3 राइफल्स फ्रॉम बी, सो वो वही भेजता है, सेंड 3 राइफल्स भेजता है. जबकि वो टेलीग्राफ वाला कंपनी क्या कर देता है, सेंड 3 राइफल्स की जगह सेंड द राइफल्स का मैसेज रिले कर देता है बी को. सो बी को लगता है शायद 50 के 50 सारे राइफल्स भेज दूंगा, बिकॉज ए ने पहले टेलीग्राफ में बोला था कि आई एम इंक्वायरिंग अबाउट द प्राइस ऑफ योर राइफल्स एंड आई मे बाय एज मेनी एज 50, जबकि ए ने एक्चुअली उसको बाद में 3 ही मांगे थे. So what A did, वो 50 राइफल आए, उसने 3 रख लिए और वापस भेज दिया. So this was a mistake regarding to the quantity of the subject matter, right? So the court later ruled that yes, this was a mistake, but since A ने 3 राइफल रखा है, तो he is liable to pay only the price of the 3 rifles. So this is a case of Hankel versus Pope. Next, the contract में mistake may be as to the possibility of performance. Let's say जो contract आप बनाने के लिए सोचे थे, that has become impossible. कैसे impossible? Firstly, physical impossibility. जो contract है, that's no longer possible to be carried out in a physical sense. This is taught through a case of Griffith versus Brymer. So this was the case of perhaps King George V or someone. Let's just say England का एक राजा था जिसका coronation procession होने वाला था. So the Raja was to be coronated, and this was to be done through a particular important street. So people from all over the kingdom were really excited about this, and they wanted to be a part of it. So वो बहुत try करके hire कर रहे थे hotel services on the street. So Griffith या Brymer में से कोई भी एक, he had a hotel and it was to be given on rent. So वो जो देने वाला था rent और B ने उसको pay भी कर लिया था. They later realized that B only wanted to get that hotel for a particular period of time because he wanted to watch the coronation procession. Later क्या हुआ कि वो जो राजा बनने वाला था उसकी तबीयत खराब हो गई and coronation procession was cancelled that day. So that is why the contract became physically impossible, and B ने बोला कि मुझे और room नहीं चाहिए, and therefore he deserved compensation, जो कि उसने price दिया था hotel room के लिए उसको लौटा दिया गया. Legal impossibility. Let's say you agree to sell something जो कि बाद में जाके बैन ही हो जाता है. So now it's become impossible. Let's say you are someone who trades rice, मतलब राइस बेचते हो. गवर्नमेंट डिक्लेयर करती है कि ड्राउट का समय है and that's why rice is to be rationed, you cannot sell it. That is why it is legal impossibility. So mistakes के दो types हमने पढ़ लिए, as to the subject matter of the agreement or the contract and as to the possibility of performance of the contract. Next is a unilateral mistake. मतलब दोनों की तरफ का mistake नहीं है, ये एक ही person का mistake है. As to the identity of person contracted with, जो कॉन्ट्रैक्ट आप कर रहे हो, यू आर मेकिंग इट अज्यूमिंग कि आप दूसरे वाले पर्सन की सच्ची आइडेंटिटी जानते हो, राइट? A woman fraudulently represents herself as the wife of a zamindar to the jewelers and obtained 2 pearl necklaces. There was no contract established. ये later rule हुआ and the woman had to return the 2 necklaces. चाहे वो पे भी कर लेती, लेकिन the point was that उसने ज्वेलर्स को fraudulently represent किया कि मैं और कोई हूं. So this was the identity of a person which was misrepresented and that's why this is a mistake. As to the nature of contract, nature of contract की तरफ mistake क्या हो सकता है? A hired a taxi and asked the driver to give him a receipt for the fare paid, right? The driver, being illiterate, asked A to write it himself. ड्राइवर बोला मैं तो पढ़ाई लिखाई नहीं कर सकता, सो आप प्लीज खुद एक रिसिप्ट लिख लीजिए एंड फिर मैं उसे साइन कर लूंगा. ए ने बड़ी चालाकी करके क्या किया? He got a promissory note for 1,000 rupees signed. Promissory notes are not actual notes, but it is something like I promise to give you later, right? So उसने वो B से sign करवा लिया. So this is also void on the ground of mistake as to the nature of contract. B नहीं चाहता था कि वो कोई पैसा promise करे, right? He wanted a receipt for the fare. So that is why this is a mistake regarding to the nature of contract. So now comes the interesting part. It is a question which came in CLAT 2023 perhaps. So we'll go through this step by step. When parties to a contract are under a mistake regarding an important fact related to such contract, it may affect the contract in 2 ways. कौन-कौन से 2 ways में parties को affect करेगा और contract को affect करेगा अगर वो दोनों mistake में है? Firstly, it may defeat the consent altogether. जो consent parties are supposed to have given, वो consent अब है ही नहीं, वो defeat हो चुका है because there is such a big mistake about the important fact. That is where the mistake does not defeat consent but only misleads the party. मतलब consent पूरी तरह से defeat नहीं हुआ है, बस थोड़ा mislead हो गए हैं. That is where both parties to an agreement are under a mistake as to a matter of fact essential to the agreement. वो mistake में है और इसे कोई छोटी मोटी चीज की mistake नहीं है. एक ऐसा matter है, एक ऐसा fact है जो which is fundamental to their contract, right? So this agreement is void. However, if the mistake is concerning an erroneous opinion regarding the value of subject matter of the agreement, it is not a mistake as to a matter of fact. So जब मतलब ऐसा है कि मैं तुम्हें बेस्ट क्वालिटी देना चाहता था and you are now arguing कि नहीं ये तो बेस्ट क्वालिटी नहीं है, so that is something that's subjective opinion, right? So वो एक erroneous opinion है regarding the value of subject matter. It is not a mistake as to matter of fact. Thus an agreement is void only when both parties to an agreement are mistaken. Their mistake is as to a matter of fact. The fact about which they are mistaken is essential to the agreement. So ये 3 required conditions हैं, which we'll discover later through the questions. Further, it is pertinent to note that a mistake in order to invalidate a contract should be a mistake of fact and not a mistake of law. अगर आप दोनों एक law के mistake किए हो, that will not make your agreement void. Because a principle है ignorantia law not excused, right? So like ignorance of law is not something that is a defense, right? You cannot say कि मुझे ये law पता नहीं था and that's why you broke it. So furthermore, where only one party to the contract is under a mistake of fact and the other party is not, the contract is not voidable merely for such reason. अगर सिर्फ एक ही पार्टी का mistake है, they are under a mistake of a fact and the other party is not, the contract is not voidable. The first question. Mr. A entered into an agreement to sell his bicycle, which had been kept unused in his attic for a year, to Mr. B at an agreed price. Neither party was aware that at the time of entering into the agreement, जो bicycle था Mr. A का, जो वो बेचने वाला था B को, that had already been destroyed by a fire in the attic. In the given situation, which of the following statements is true? Right. So we पूछा जा रहा है इन चारों options में से कौन सा true है. I'd encourage you to participate in this and unmute yourself and say the answer if you can. Right. So let me read the options first. A. The agreement is void as both parties were under a mistake as to a matter of fact essential to the agreement. मतलब agreement void है because दोनों parties एक mistake में थे, which was a mistake as to a matter of fact which was essential to the agreement. B. The agreement is void as both parties were under a mistake as to a law in force. The agreement is not voidable as only one of the parties was under a mistake. The agreement is not voidable as the promise made under the agreement had not been performed. So, does anyone want to answer this question? Sure, go ahead. A agreed to sell his bicycle to B, but at the time of saying that, they had no idea the bicycle had already been destroyed by a fire in the attic. Very similar to the example which I had given earlier. So here the correct option should be, you can text it in the chat as well. Yeah, very good. As most of the people have said, it's A. Because this was an agreement जिसमें mistake हुआ है and mistake वो भी हुआ है as to a matter of fact which is essential to the agreement, right? That is why the agreement is void because वो bicycle और था ही नहीं. Moving on to the next question, Miss X and Miss Y entered into a contract of sale of an article, right? दोनों agree किए एक article sale होगा, while reeling under the erroneous belief that the sale of the article, which was the subject matter of the agreement, was permitted by law in force in India. So दोनों को लगता था जिस आर्टिकल को हम परचेज और ट्रांजैक्शन करने की बात कर रहे हैं जिसका कॉन्ट्रैक्ट हुआ है, इट इज परमिटेड इन इंडिया. So in the given situation, which of the following statements is true, right? The contract is valid, the contract is voidable at the option of Miss X, the contract is voidable at the option of Miss Y, the contract is not voidable. So remember, दोनों का mistake ये था कि उनको लगा था जो आर्टिकल का हम सेल करने वाले हैं that is permitted by the law in force in India. Remember. So accordingly, I would love to have your answers.
It says D because it's void ab initio. Like,
very good, very good. Right. So this is a fact. This is a mistake, not as to a matter of fact, but as to a matter of law. Right. So that's what it was said, that when the mistake is only regarding a fact, then only we can have the contract be called void. Right. So the correct option is the contract is not voidable. Very good. So next question. Mr. J entered into an agreement with Mr. K for the sale of Mr. J's club. At the time of entering into the agreement, while Mr. J believed that he was agreeing to sell his golf club, Mr. K believed that he was agreeing to buy a clubhouse owned by Mr. J. So ये सोच रहा था कि मैं अपना golf club उसको दे रहा हूँ, बेच रहा हूँ उसके लिए, and K सोच रहा था कि he was actually buying a clubhouse. So the agreement is void because question already बोल दिया कि agreement void है. You just have to find the correct answer or the reason to it. Mistake of fact defeated the consent of the parties. Mistake of fact misled the parties as to the purpose of the contract. Mistake of fact was regarding the identity of parties, both A and B. So, does anyone have any answer in their mind?
Both A and B.
Very good, very good. So the mistake of fact defeated the consent of the parties. Yes, because दोनों का consent एक दूसरे के लिए exact same thing or same sense में नहीं था. And the mistake also misled parties as to the purpose of the contract. उनका purpose भी बदल गया, and that's why it is void. So the correct option is D for 103. 104 says, Mr. D appointed Mr. K to manage the cultivation of his land as he was unable to manage it himself due to his advanced age. So D बूढ़ा हो गया है, and he is saying that Mr. K, तुम थोड़ा manage कर लो मेरा land का cultivation, and K agree कर लेता है. If he granted Mr. K, मतलब मुझे तुम अपना land का एक lease दो, and उसके बाद I'll agree to manage the cultivation of your land. So Mr. D agree कर लेता है and signed a deed which was unknown to both parties, a gift deed of the land and not a lease deed. So what Mr. D was supposed to do, he was supposed to sign a lease deed for Mr. K. But उसने क्या कर लिया? He's already due to his advanced age or something like that, he has signed a gift deed. Gift deed मतलब उसको पूरा gift कर दिया. जबकि lease एक different contractual arrangement होती है, right? So in the given situation, which of the following statements is true? Mr. D and Mr. K were reeling under a mistake as to a matter of fact essential to the agreement, as to a matter of law essential to the agreement, reeling under a C और D में difference क्या है देखो, A और B में दोनों parties under mistake हैं, और option C and D says that only Mr. D was reeling under a mistake of fact as to a mistake of fact, मतलब matter of fact या matter of law. So which one do you think is the correct option?
Is it option A?
Very good, because the question says that Mr. D signed a deed which was unknown to both parties. मतलब both parties were reeling under a mistake. और mistake कैसा था? Fact का था या law का था? Fact का था. Because he was supposed to have signed a lease deed, and what he instead chose is a gift deed. Very good. The next question. Miss X and Miss Y entered into a contract of sale of an article which was agreed to be shipped by Miss X in a ship named the Cruiser. Okay, so X और Y एक contract में गए और Miss X ship करेंगी वो article Cruiser नाम के एक ship में and deliver करेंगी Y को on an agreed date, right? Miss X, okay, sorry, it's Mr. or Miss, they change it. Mr. X shipped the said article by a different ship named the Mariner without informing Miss X, and the article was delivered to Miss Y on the agreed date. So देखो, X ने Y को भेजना था, but उसने क्या किया, वो क्रूजर में ना भेज के मैरिनर में भेज दिया. Okay, but article deliver हो गया on the agreed date. So in the given situation, which of the following statement is true? The agreement is void as to both parties were under a mistake as to a matter of fact essential to the agreement, as to a mistake as to a law in force. The agreement is valid as both parties were under a mistake as to a matter of fact not essential to the agreement. The agreement is valid as both parties were under a mistake as to a matter of fact essential to the agreement.
Option A.
Okay, let me just go through the question quickly. So Miss X को Miss Y को भेजना था एक आर्टिकल, राइट? और उसे भेजना था ऑन मतलब बाय एन अग्रीड डेट, राइट? सो दे अग्रीड कि वो एक शिप क्रूजर में से जाएगा, ओके? बट उसने क्या किया, उसने Y को वो आर्टिकल सेम डेट पे मतलब सेफली पहुंचा दिया, बट एक डिफरेंट शिप से, द मैरिनर से. ऑल राइट, सो थिंक अगेन, शुड दिस अग्रीमेंट बी वॉइड और शुड दिस अग्रीमेंट बी वैलिड? फर्स्ट ऑफ ऑल,
I think it should be valid.
Because, could you cite a reason?
Because they agreed, like the item was delivered, the good was actually delivered, so the contract had been completed.
Very good. So the agreement is valid as both parties were under a mistake. No doubt they were, उनका mistake था कि वो एक ship में से भेजने वाला था, उसने दूसरे से भेज दिया. But the mistake was not as to a matter of fact which was essential. That is what option C says. That they were under a mistake as to a matter of fact not essential to the agreement. Ship जो मतलब कौन सा भी हो, the what the point is that item delivered हो गया है by the said date. So very good everyone. Let's head to the next chapter of this topic. So this is a different section of contracts. We have already established the fundamentals. Now we'll delve into special forms of contracts. So there are specific contracts जिसके बारे में हम पढ़ सकते हैं. So these are a little higher level, but they may appear in the exam. No one knows. Contract of agency. हम start कर रहे हैं contract of agency से. So an agent is a person employed to do any act for another or to represent another in dealings with third persons. So ऐसा एक है कि मेरा एक agent मैंने hire किया है. What is the work of that person? He is employed. उसको मैंने employ किया है मेरे behalf में कोई act किसी और के लिए करे या फिर मुझे represent करे in dealing with a third person. So the agent का एक special चीज है. The agent himself or herself can be a minor. The person for whom such an act is done or who is so represented is called the principal. मतलब मेरे लिए वो कोई काम कर रहा है, so I am the principal and the person जिसको मैंने employ किया है is the agent. So any person who is of the age of majority and has a sound mind is capable of becoming a principal. So remember, मैं किसी को hire कर सकता हूँ as agent so long as I am of the age of majority, 18 साल हो गया है, and I am of sound mind. But the agent can be a minor. Note, a domestic servant who renders to his master a personal service won't be termed an agent. Only an agent, a person becomes only an agent when one acts as a representative of the other in business negotiations or has derivative authority to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence in his own case. So let's break down what this note says. This note says कि मैं मेरे घर में कोई आके काम कर रहा है, the domestic servant who is rendering me personal service वो मेरा agent नहीं है. To become an agent, what you need to do is you should be acting as a representative of me, कुछ business negotiations करने के लिए, कोई act करने के लिए, और you should have some derivative authority. मतलब मेरे behalf में you are empowered, you are legally employed to do some acts. किसके लिए? ऐसा act so that मुझे कोई loss ना हो. मतलब जो चीज मैं करने मतलब ideally I am supposed to do it, what I'm doing it, I'm giving my authority away to an agent and they are being employed to ensure that principal को loss नहीं होता. They cannot ensure कि 100% loss नहीं होगा, but what they should do is that they should try as much as a person of ordinary prudence, मतलब जो ordinary दिमाग से चलता है, what a person will do in his or her own case, खुद को loss से बचाने के लिए उतना तुम्हें करना पड़ेगा. So firstly, consideration is not necessary for the creation of agency. Let's say मैं तुम्हें agent employ करता हूँ और मैं तुम्हें पैसे कुछ नहीं देता. That is still a contract of agency. इसमें तुम्हें consideration कुछ नहीं चाहिए. Consideration, let me remind you, is something that you give each other in a contract. A lawful consideration is required in a contract, but in the case of agency, there is an exception. It's not required for the creation. The principal shall be liable for acts done by the agent, which he has been authorized to. So let's see, मैंने एक agent hire किया है और acting in his official capacity, मतलब as an agent, उसने कुछ किया. So I will be personally liable for the acts conducted by the agent because it is being assumed कि वो मेरे behalf में ही सारे acts कर रहा है. Let's look at an example. A appoints B as his agent to carry on his business of a shipbuilder. B may require, मतलब purchase the required materials and hire workmen for the purpose of carrying on his business. Okay. So देखो, A ने B को अपॉइंट किया कि तुम मेरे एजेंट हो और तुम एक शिप बिल्डर का बिजनेस मेरा चलाओगे. So वो as soon as he employed him as an agent, B will be required to do all such acts जो कि उसे करना चाहिए so that मतलब एक reasonable manner में सब चीज function हो. So वो required materials को purchase कर सकता है. He can even hire workmen for the purpose of carrying on the business. जबकि business actually B का नहीं है, but since he has been employed as an agent, he is empowered to do these things. Termination of agency. Agency खत्म करना है. So the principal revoking his authority. This is one way to terminate the agency. Principal revoke कर रहा है कि नहीं agency तुम और नहीं कर सकते. Agent खुद renounce कर रहा है the business of the agency, right? So वो खुद बोल रहा है कि मुझे और ये business नहीं करना है. और वो बिजनेस जो एम्पावर किया गया था, फॉर एग्जांपल शिप बिल्डर का बिजनेस किया था, शिप बन गया, वो पोर्ट भी हो गया. सो उसके बाद उसका एजेंसी खत्म हो गया, राइट? सो कंप्लीटेड. Either of them dying or becoming of unsound mind, principal is being adjudicated and insolvent. I told you that the competent parties होने के लिए you should also not be an insolvent. Insolvent मतलब you are like bankrupt and you have no power to carry on a contract. So अगर principal वैसा हो गया तो वो तो नहीं कर सकता और agency automatically dissolve हो जाएगी. So let's look at an example. A had authorized B to be his agent for various tasks concerning banking and dies in an accident. So A मर गया है. So A ने जो B को अपने बैंकिंग के टास्क करने के लिए एजेंट एम्प्लॉय किया था, B cannot do any more transactions on behalf of A as his agency is terminated. So और कुछ केसेस हैं जहां पे एजेंसी को रिवोक नहीं किया जा सकता, where the agent has already exercised his authority or incurred personal liability. So let's see, तुम्हें कुछ काम दिया गया था, you have already performed the task. Once it's performed means वो इम्प्लाई करता है कि वो टास्क एक्चुअली प्रिंसिपल नहीं किया है अपने एजेंट के थ्रू. सो उसके बाद तुम वापस से रिवोक नहीं कर सकते. फॉर एग्जांपल, ए साइंस सम पेपर्स व्हिच हैव डेट्रिमेंटल क्लॉजेस ऑन बी's बिहाफ एज हिज एजेंट. सो देखो, ए है एजेंट, बी के बिहाफ पे वो कुछ साइन कर रहा है और वो ध्यान नहीं दे रहा जो पेपर साइन क्या है. इट हैज सम क्लॉजेस व्हिच आर नॉट गुड. मतलब गुड किसके लिए नहीं है? दे आर डेट्रिमेंटल फॉर बी. B gets to know that A did not read them properly. B को गुस्सा आया. The papers shall still be deemed to be signed by him. The agency cannot be revoked. Just because A ने कोई गलती कर ली B के behalf agent act करते हुए, that does not mean कि B instantly उसको withdraw कर लेगा कि नहीं ये तो मैंने नहीं किया, I revoke this agency, because this agent has already exercised his authority and the papers are deemed to be signed by him. So I hope there are no doubts. Next form of contract we're going to look at is a contingent contract. सो कंटिंजेंट कॉन्ट्रैक्ट मींस एक ऐसा कॉन्ट्रैक्ट विच डिपेंड्स, मतलब कॉन्ट्रैक्ट उस समय तक एनफोर्सेबल नहीं होगा जब तक कोई और एक कंडीशन विच इज कोलैटरल टू दिस कॉन्ट्रैक्ट नहीं हुआ है. मतलब टू डू और नॉट टू डू समथिंग if some uncertain future event collateral to such contract does or does not happen. मतलब तुम ऐसा चीज कर रहे हो कि you are thinking कि ये कॉन्ट्रैक्ट तभी होगा या नहीं करेंगे हम ये जब कोई अनसर्टेन फ्यूचर इवेंट, ऐसा फ्यूचर इवेंट जो कि उसकी पॉसिबिलिटी तुम पहले से पूरा प्रेडिक्ट नहीं कर सकते कि वो होगा ही, इट शुड नॉट बी सर्टेन, बट वो अगर हुआ देन ये कॉन्ट्रैक्ट होगा, कि अगर वो नहीं हुआ देन ये कॉन्ट्रैक्ट होगा, तो इट्स सच अ कॉन्ट्रैक्ट, राइट? So thus it cannot be enforced by law until and unless that event has happened. If the event is sure to happen, the contract is not contingent but an absolute one. So contingent होने के लिए जिस event पे आप depend कर रहे हो, it should be something which should be uncertain. For example, there is a contract between A and B, where A has to sell his goods which are in a voyage to B if the ship reaches the harbor safely. So ये जो कॉन्ट्रैक्ट है कि ए मैं तुम्हें तभी बेचूंगा मेरे गुड्स जब मेरे शिप मतलब मेरा शिप हार्बर पहुंच जाएगा सेफली, thus contingent upon the happening of an uncertain event in a fixed period. So the moment the ship reaches the harbor, A would be required to sell his goods. So contingent contract becomes enforceable as long as the event जिस पे वो contingent था, it has happened. A promises to buy B the Indian cricket team's jersey if they win the match today. ए प्रॉमिस करता है बी को कि I'll buy you a jersey अगर इंडिया जीत जाती है मैच. However, if A promises to buy B the jersey, if he pays him the money, then this will be a promissory condition that depends on the performance of a duty. So see, this should depend on a future event. इंडिया अगर मैच जीतेगा, I'll buy you a jersey. बट अगर ए बोलता है कि मैं तुम्हें जर्सी दूंगा, बी बोलता है मैं तुम्हें 100 रुपए दूंगा, I'll pay you money, this is not a contingent contract, right? This becomes a promissory condition. So ड्यूटी परफॉर्म कर रहे हैं दोनों. This becomes a normal absolute contract. The contract becomes void if the event is or becomes impossible. ऐसा भी नहीं है कि तुम ये बोल रहे हो कि जो भी इवेंट पे बोल देंगे. The event should be realistically possible, जिसकी certainty पे तुम कोई कमिट नहीं कर सकते. For example, A agrees to pay B rupees 1000 if B will marry A's daughter C. और ये करते वक्त C already dead है. So at the time of this agreement, making it void. The event जिस पे तुम contingent रख रहे हो contract को, that is something which is impossible. So here it's not a contingent contract. We'll learn about its difference from wagering agreement. So a wagering agreement is something which is a bet. तो आप सबको पता होगा bet क्या होता है. So bet में you have two parties जो कि कुछ दांव पे लगा रहे हैं, and it is such a case that एक पार्टी जीतेगा, दूसरा पार्टी लूज करेगा, right? So bet is something stated to be lost or won on the result of a doubtful issue. That is the condition that money is payable by the first party to the second party on the happening of a future uncertain event, and the second party to the first party when the event does not happen. So in this case, a bet or a wagering agreement क्या होता है? There is a reciprocal promise कि अगर ये चीज हुई मैं तुम्हें 100 रुपए दूंगा, अगर ये नहीं हुई तुम मुझे 100 रुपए देना. So wagering agreement is a void agreement, remember. So one party is to win, the other is to lose. Reciprocal promises for each other. So wagering agreements different कैसे हुए contingent contract से? I'll show you through an example. A and B enter करते हैं into an agreement which provides that if England's cricket team wins the match, A will pay B rupees 100. And if it loses, B will pay rupees 100 to A. Nothing can be recovered by the winning party under this agreement, it being a wager. So jabki we had seen that contingent contracts were enforceable by law, they were legal. Wagering agreements are void and they cannot be enforced. Q, because contingent contract में there may or may not be any reciprocal promise. As you will remember, A promise किया था B को कि I'll buy you Indian cricket team's jersey अगर वो जीत जाए match. So this was not a bet. This was something कि इस इवेंट पे कंटिंजेंट है हमारा कॉन्ट्रैक्ट फुलफिल होना. जबकि ए और बी क्या कर रहे हैं? दे आर एंगेजिंग इनटू बेटिंग, जिसमें एक पार्टी जीतता है, दूसरा पार्टी लूज करता है, एंड देयर इज एन एक्सचेंज ऑफ मनी. सो दैट इज व्हाई दिस इज अ वेजर. एज यू ऑलरेडी नो, गैम्बलिंग एंड ऑल वैसी चीजें वेजरिंग के अंदर आती है, एंड इट इज ओनली परमिटेड इन सम प्लेसेस. सो आई होप दैट्स क्लियर. We'll head to contract of bailment. So bailment क्या होता है? हमने दो चीजें पढ़ ली, एजेंसी पढ़ ली, contingent contract पढ़ लिया. And now we're going to study about contract of bailment. The delivery of goods by one person to another for some purpose. एक person मैं हूँ और तुम हो. I am the bailer, you are the bailee. जो goods मैं तुम्हें दे रहा हूँ, I am the bailer, and जिसको दिया जा रहा है, he is the bailee. क्यों दे रहा हूँ? कुछ purpose है मेरा. upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the persons delivering them. So see, मैंने तुम्हें जो goods दिया वो मैं ऐसे दे रहा हूँ अंडर अ कॉन्ट्रैक्ट दैट जब मेरा पर्पस अकॉम्प्लिश हो जाएगा आइदर तुम मुझे वो रिटर्न कर दोगे या फिर डिस्पोज करोगे अकॉर्डिंग टू माय डायरेक्शंस. एग्जांपल, ए डिलीवर्स द रेडियो टू बी फॉर सर्टेन रिपेयर्स. ए ने बी को कुछ रिपेयर करने के लिए रेडियो दिया. हम सब करते हैं, हमारा मोबाइल फोन रिपेयर करने के लिए शॉप को जाते हैं. सो जब वी डिलीवर आवर फोन टू द शॉपकीपर कि आप इसको रिपेयर कर दो, दिस क्रिएट्स अ कॉन्ट्रैक्ट ऑफ बेलमेंट. A lends a book to B to be returned after examination. This is a contract of bailment between A and B. Exam खत्म हो जाएगा, purpose accomplish हो जाएगा, तो तुम वो book मुझे वापस दे देना. This is the contract of bailment. So the essence of a bailment is the transfer of possession, right? The possession is changing hands. Ownership remains with the owner. मेरा मोबाइल फोन जो कि मैं शॉप में दे रहा हूँ, that does not become the owners under the ownership of the shopkeeper. It's still my phone. But what I'm doing is कि वो possession जो मैं उसे possess कर रहा था, I'm handing it over to the shopkeeper. So there cannot be a bailment of immovable property. मैं अपना land को नहीं दे सकता. The land is an immovable property, right? So this cannot be transferred because उसका ownership आप change नहीं कर सकते. Essentials. Bailment का contract आप होने के लिए what are the following conditions required? Firstly, there's a conditional delivery. For example, when stitching is complete, tailor is supposed to return the garment to the tailor. So जो bailment आप कर रहे हो, it should include a conditional delivery कि ये हो जाए या पर्पस कंप्लीट हो जाए, आप उसे वापस कर दो या फिर डिस्पोज करो. जैसे भी आप एक टेलर को अपना कपड़ा दे रहे हो एंड आफ्टर द स्टिचिंग इज कंप्लीट, टेलर इज सपोज्ड टू रिटर्न द गारमेंट टू द बेलर. अगर वो नहीं करता है, दिस कॉन्ट्रैक्ट ऑफ बेलमेंट इज बीइंग इन्फ्रिंज्ड एंड यू कैन sue फॉर द ब्रीच. Secondly, duty of bailee to take reasonable care of goods. I hope you remember, जो दे रहा है he's the bailor, जिसको दिया जा रहा है he's the bailee. So जब उसको दिया गया, the bailee owes some duty कि वो जो वो goods है उसका reasonable care लेगा वो. For example, कैसे लेगा? The bailee being bailed of pets. Suppose I'm heading out of station and I'm giving you my pet dog कि आप इसको थोड़ा रख लो एक दिन के लिए. I'll come back to you. So the bailee being bailed of pets is expected to feed the pets and provide necessities to them. They cannot say कि तुमने तो सिर्फ बोला था pet को रखने के लिए and we just let him and उसको खाना नहीं दिया and he starved and died. No, you should have to take reasonable care of the goods. Thirdly, not to make unauthorized use of goods, liable to pay compensation for any use not according to the conditions of the bailment. For example, मैंने तुम्हें मेरा pet horse दिया था. A leaves his pet horse with C, जबकि A business trip पे गया है. सी क्या करता है, उस पेट हॉर्स को सिर्फ रखने के सिवाय उस पर बहुत अनड्यू प्रेशर डालता है, एक रेस में पार्टिसिपेट करवाता है एंड जिसकी वजह से द हॉर्स ट्रिप्स एंड फॉल्स एंड वो इंज्योर हो जाता है. नाउ सी मस्ट कॉम्पेंसेट फॉर दिस इंजरी बिकॉज जब बेलमेंट का कॉन्ट्रैक्ट एस्टैब्लिश हुआ था, देयर वाज नो रीजनेबल सेंस कि उसको सी ऐसे एक फिजिकली स्ट्रेनुअस रेस में पार्टिसिपेट करने के लिए फोर्स करवा सके, राइट? सो यू शुड नॉट मेक अनऑथराइज्ड यूज ऑफ द गुड्स व्हिच हैव बीन बेल्ड टू यू. Fourth, rights of finder of goods. So a special form of bailment arises. देखो bailment के लिए naturally you should have two parties who have actually talked to each other कि हाँ ये होगा वो होगा. लेकिन एक special sort of bailment कहाँ होता है? Finder of goods. Let's say आपको कुछ चीज मिलती है जो आपको पता है वो आपकी नहीं है. It's been lost by someone. So you do not actually become automatically its owner. When you have found something, you actually have a legal responsibility to keep it or to try to find the owner or keep it until the owner is found. So this creates a special form of bailment. How is it different from a pledge? Let me tell you about pledge. It is a separate form of a contract. So pledge में क्या होता है? The purpose differs, as here it is to secure a loan or a promise. Pledge तो आप एक स्पेशल फॉर्म ऑफ बेलमेंट समझो, जबकि वो एक्चुअली दोनों डिफरेंट है, दोनों का पर्पस अलग है. कैसे? प्लेज में क्या होता है? द बेलर और द बेली जो थे, मतलब बेलर गिविंग द गुड्स टू द बेली, हियर इट्स कॉल्ड पॉनर एंड द बेली इज कॉल्ड द पॉनी. सो फॉर एग्जांपल, ए नीड्स मनी फ्रॉम बी. ए को बी से मनी चाहिए एंड वो क्या करता है, अपने एक वॉच को बी को देता है और उसे बोलता है आप ये रखो एज सिक्योरिटी इन एक्सचेंज फॉर द बोरोइंग. ये एक सिक्योरिटी है, मतलब जैसे बोलते हैं ना कि डेब्ट के लिए कोलैटरल कुछ रखता है, वैसे ही what you're doing is you are actually securing a loan, मतलब और एक promise कि B तुम मुझे money दो and in exchange for this borrowing I'm giving you my watch to be kept as security. So A is the pawner here and B is the pawnee. The pledgee acquires a special property. Pledgee और pawnee दोनों सेम चीज है, मतलब B जिसको watch मिला है वो क्या करता है, क्योंकि ये वॉच उसको इन रिटर्न फॉर बोरोइंग मिला है, इन रिटर्न फॉर अ प्रॉमिस और टू सिक्योर अ लोन, द प्लेजी एक्वायर्स अ स्पेशल प्रॉपर्टी इन द गुड्स प्लेज्ड, whereby he gets possession coupled with the power of sale on default. देखो, बेलर और बेली जब थे, उन दोनों का बहुत सिंपल था, मैं तुम्हें अपना पेट दे रहा हूँ, उसको थोड़ा रखो, एक दिन के बाद आके मैं ले जाऊंगा. दिस इज अ बेलमेंट. आई एम नॉट डूइंग इट टू सिक्योर एनीथिंग इन रिटर्न फ्रॉम यू. एंड जबकि प्लेज में पर्पस ये है कि यू आर ट्राइंग टू सिक्योर अ लोन और अ प्रॉमिस, राइट? सो इधर जब आप बी को अपना वॉच दे रहे हो एंड इफ यू डिफॉल्ट ऑन योर डेब्ट, फॉर एग्जांपल आप रिटर्न नहीं करते हो वो पैसा, what B has the power is he can actually sell the watch as well. While Bailey, मतलब bailment में Bailey has no right to sell. Pawnee or the pledgee can sell the goods after due notice to the pawner. If A default करता है, वो security जो दिया था वो lapse हो जाता है. मतलब जितना पैसा A ने B से लिया था, उसको वो B कैसे लेगा? He can actually go ahead and sell this. So pledge में ये difference है from bailment. Does anyone have any doubts up until now?
No.
Sure. Thank you. Now we'll head to contract of indemnity and guarantee. So bear with me, please. This is a little complicated. Indemnity में क्या होता है? A person promises to save the other from loss caused to him by the conduct of the promiser himself or of any third person. So मैं क्या कर रहा हूँ? मैं तुम्हें श्योर कर रहा हूँ कि तुम्हें जो भी लॉस होगा मैं उसकी भरपाई कर दूंगा. लॉस कैसे होगा? लॉस हो सकता है बाय द कंडक्ट ऑफ द प्रॉमिसर, मेरे द्वारा ही लॉस हो सकता है, या फिर किसी और थर्ड पर्सन की वजह से वो लॉस हो सकता है. The person who gives the indemnity is called the indemnifier, and the person for whose protection it is given is called the indemnity holder or indemnified. So मैं तुम्हें indemnify कर रहा हूँ, मतलब I am the indemnifier, and जिसको मैं protect कर रहा हूँ, he is the indemnity holder or the indemnified. The loss must be caused by some human agency, not arising from accidents like fire or perils of the sea. जो लॉस तुम्हें होगा और जिसकी कंपेंसेशन मैं तुम्हें दूंगा, तुम्हें प्रोटेक्ट करूंगा, इट शुड बी ड्यू टू द सम ह्यूमन एजेंसी, लाइक मेरी वजह से हो सकता है या किसी और की वजह से हो सकता है, बट इट शुड नॉट बी रिजल्टिंग फ्रॉम एक्सीडेंट्स लाइक फायर हो गया या सी में कुछ हो गया. फॉर इंस्टेंस, in case of home insurance, homeowners pay insurance to an insurance company in return for the homeowners being indemnified if the worst were to happen. The insurer is the indemnifier who promises to financially reimburse the homeowners as indemnity holders. Insurance का केस है सबसे सिंपल वाला. Homeowners आप एक पैसा दे रहे हैं इंश्योरेंस कंपनी को, in return की जब कुछ हो जाए घर को, तो you will be indemnified from the loss. जो आपको इंश्योर कर रहा है, the insurance company, they are the indemnifier, and you, the homeowners, are the indemnity holders. अब contract of guarantee क्या है? So we'll talk about the difference in a while, but let's just focus on contract of guarantee for a second. Contract to perform the promise or discharge the liability of a third person in case of his default. इधर तीन लोग इन्वॉल्व होते हैं. गारंटी में क्या होता है कि आई एम प्रोमिसिंग टू समवन कि अगर तुम ये काम नहीं कर सकते, लेट्स से दो जन कॉन्ट्रैक्ट में है, तीसरा जन क्या कर रहा है कि अगर ये वो कॉन्ट्रैक्ट नहीं कर पा रहा, फेल कर रहा है, I'll discharge it, I'll perform the promise in case of his default. So here the person who is giving the guarantee is called the surety. The person in respect of whose default the guarantee is being given is called the principal debtor, and the person to whom the guarantee is being given is the creditor. We'll understand this through an example. A advances a loan of 5,000 rupees to B. Okay, A ने B को 5,000 रुपए लोन दिया. C प्रॉमिस करता है A को, जिसने लोन दिया है, that अगर B रिपे नहीं कर पाता है लोन, I will do it for him. This is a contract of guarantee. A ने लोन दिया, he is the creditor. C ने गारंटी दी कि मैं B के डिफॉल्ट के केस में कॉम्पेंसेट कर दूंगा, I will discharge this contract. He is the surety or the guarantor. B जिसके बिहाफ पे ये गारंटी दी गई है, he is the principal debtor. All right. So we'll discuss the difference between indemnity and a guarantee through this story. John है, he books a package holiday through his travel agent, which includes a hotel stay. All right. So एक travel agent है जिसके through John एक package holiday book कर रहा है जिसमें उसको एक hotel में रहने को मिलेगा. And as a part of this package holiday contract, there is an indemnity clause. वो clause क्या बताता है कि if John causes any damage to his hotel room, he is required to compensate the hotel. So इधर क्या होता है कि जॉन अगर कोई डैमेज करता है, he has to indemnify the hotel. All right, he will compensate. So this is a contract of indemnity. There is also a guarantee in the contract signed by the travel agent that says if John is unable to indemnify the hotel for the damage, the travel agent promises to compensate the hotel on John's behalf. So you see, इधर दो चीजें हो रही हैं. In this case, the hotel is protected against any losses either through John directly or by a third party, the travel agent. The guarantee only comes into effect if the primary obligation identified by the indemnity clause, in this case, John paying for the damages he caused, cannot be fulfilled. So guarantee और indemnity दोनों exist कर रहे हैं इस case में. But हो क्या रहा है? Firstly, the contract is of indemnity, जहां पे जॉन ने इंडेमनिफाई किया है होटल को कि मेरी वजह से या किसी और की वजह से मेरे रूम में कुछ एक लॉस हो तो आई विल कॉम्पेंसेट. दैट इज द कॉन्ट्रैक्ट ऑफ इंडेमनिटी. उसके बाद उसका ट्रैवल एजेंट क्या कर रहा है? दिस इज अ कॉन्ट्रैक्ट ऑफ गारंटी वेयर द ट्रैवल एजेंट सेज कि अगर जॉन इंडेमनिफाई नहीं कर पा रहा है होटल को डैमेज से, आई विल कॉम्पेंसेट द होटल ऑन जॉन्स बिहाफ. सो इधर गारंटी का कॉन्ट्रैक्ट तभी आएगा इफ द प्राइमरी ऑब्लिगेशन, वो क्या था, which was been identified by the indemnity clause, in this case John paying for the damages he caused, cannot be fulfilled. अगर वो प्राइमरी ऑब्लिगेशन मतलब प्रिंसिपल डेप्टर का नहीं हो पाया, तभी वो श्योरिटी वाला बंदा आएगा, राइट, जो कि बोलेगा कि हाँ मैं कर देता हूँ तुम्हारे बिहाफ में. So indemnity and guarantees are not either or scenarios. Instead, they offer layers of protection. I hope everyone understood. Does anyone have any doubt? All right. So we are heading to the distinction. फिर से clear कर लेता हूँ. Firstly, a contract of indemnity. In this contract of indemnity, there are two parties: the indemnifier and the indemnified. जबकि contract of guarantee में there are three parties: surety जो कि guarantee देता है, the principal debtor जिसके behalf पे guarantee दी गई है, and the creditor जिसने भी first of all सब किया है, मतलब debtor को दिया है loan. In a contract of indemnity, the liability of the indemnifier is primary. I had said that John के case में. In a contract of a guarantee, the liability of the surety is secondary. Surety कभी मतलब तभी आएगा in the picture अगर प्रिंसिपल डेप्टर फेल हुआ, मतलब वो रीपे नहीं कर पाया लोन, तब श्योरिटी आके कॉम्पेंसेट करेगा उसके बिहाफ पे. The surety is liable only if the principal debtor makes a default, the primary liability being that of the principal debtor. So उस जॉन और होटल वाले के केस में भी प्राइमरी लाइबिलिटी थी किसकी? जॉन की थी. So John was the principal debtor, and अगर वो डिफॉल्ट कर लेता है तभी द श्योरिटी वाला बंदा जो कि वो ट्रैवल एजेंट था, he was going to come into the picture and ensure the contract of guarantee. Thirdly, the indemnifier need not necessarily act at the request of the debtor. जिसको इंडेमनिफाई आप कर रहे हो वो आप उसके रिक्वेस्ट में हमेशा एक्ट करो, वो चीज रिक्वायर्ड नहीं है. The surety gives the guarantee only at the request of the principal debtor. जब प्रिंसिपल डेप्टर खुद रिक्वेस्ट करता है कि yes, I have defaulted, I have no other means to pay, तभी श्योरिटी गारंटी दे सकता है. जबकि जिसको आप मतलब जो आप इंडेमनिफाई कर रहे हो वो नेसेसरी ये नहीं कि दूसरा बंदा आके आपको रिक्वेस्ट करे तभी आप इंडेमनिफाई करें उसको, राइट. In the case of indemnity, the possibility of any loss happening is the only contingency against which the indemnifier undertakes to indemnify. अगर कोई loss हो उसके against इस contingency, इस possibility के against I am undertaking this indemnification. And guarantee के case में क्या है ना, there is an existing debt or duty, the performance of which is guaranteed by the surety. A ने B को जो loan दिया था वो guaranteed हो कि fulfill हो, उसको कौन इंश्योर कर रहा है? The surety वाला person C, जो कि बोल रहा है कि अगर repay नहीं हुआ मैं पे कर दूंगा. The indemnifier cannot sue third parties in his own name unless there be assignment. He must sue in the name of the indemnified. Jabki the surety on payment of the debt when the principal debtor has failed to pay is entitled to proceed against the principal debtor in his own right. Let me make this clear. जो आपको कॉम्पेंसेशन दे रहा है, मतलब ए और ए ने लोन दिया था बी को, बी नहीं भर पाया वापस, सी उसको उसके बिहाफ पे ए को रीपे कर दे रहा है. सी हैज द पॉसिबिलिटी कि वो स्यू करे बी को, द प्रिंसिपल डेप्टर, कि मैंने तुम्हारे बिहाफ में ये किया, सो यू हैव टू do something for me, right? So when the principal debtor has failed to pay, the surety पेमेंट कर लेने के बाद is entitled to proceed against the principal debtor in his own right. So तीन बंदे हैं लेकिन वो प्रोसीड कर पा रहा है. जबकि इंडेमनिफायर जो है वो थर्ड पार्टीज को नहीं स्यू कर सकता इन हिज ओन नेम अनलेस देयर बी असाइनमेंट. इंडेमनिफाइड है जिसको आपने इंडेमनिफाई किया है उसी को आप स्यू कर सकते हो, राइट. नाउ विल टॉक अबाउट ब्रीच ऑफ अ कॉन्ट्रैक्ट. सो जो कॉन्ट्रैक्ट एस्टैब्लिश हुआ है वो ब्रीच कब होता है, where the promiser neither performs his contract nor does he tender performance, or where the performance is defective, there is a breach of a contract. The breach of contract may be actual or anticipatory. जब देखो कॉन्ट्रैक्ट में दो लोग होते हैं ना, द ऑफरर एंड द ऑफरी, और द प्रोमिसर और द प्रोमिसी, कुछ भी बोल सकते हो. तो द प्रोमिसर जो वो कॉन्ट्रैक्ट बोला था वो परफॉर्म नहीं करता है, या फिर वो परफॉर्मेंस देता है बट विच इज डिफेक्टिव, सो देयर इज अ ब्रीच ऑफ अ कॉन्ट्रैक्ट जो पहले एस्टैब्लिश हुआ था. द एक्चुअल ब्रीच या एंटिसिपेटरी ब्रीच क्या होता है? Actual breach matlab which takes place at the time of performance is due or when actually performing the contract. Let's say आपको कोई चीज डिलीवर करनी थी by 5th of June, आप डिलीवर नहीं कर पाए, so the contract is breached on your part, and जो जिसका violate हुआ है वो contract, that person's rights have been vitiated and they have the right to sue you, to go against you to court, to take you to court to try to get damages from you because of infringement of contract or the breach of contract. So actual breach तब होता है जबकि परफॉर्मेंस जब ड्यू है आप नहीं कर पा रहे हो, और जबकि कॉन्ट्रैक्ट परफॉर्म करने के दौरान ही आपका ब्रीच हो गया कुछ. एंटिसिपेटरी ब्रीच ये है जो कि ब्रीच मतलब हुआ है बट वो परफॉर्मेंस नहीं आया अभी तक. So it means a breach before the time for the performance is arrived. This may take place in two ways: by the promiser doing an act which makes the performance of his promise impossible. Let's say I was supposed to give you a ship, right, by 5th of June. 5th of June आया नहीं है, but मैंने क्या किया, मैंने खुद के शिप को डुबा दिया है. So this means I, the promiser, have done an act which has made this performance of the promise impossible. अब तो कुछ हो ही नहीं सकता. So this is anticipatory breach. Performance का due date आया नहीं है, but you are anticipating कि हाँ अब ये हो गया, मतलब और कुछ नहीं हो सकता. Or by the promiser in some other way showing his intention not to perform it. और मैं कुछ ऐसा काम कर रहा हूँ जो कि दिखा रहा है कि मेरा कोई इंटेंशन ही नहीं है this contract को आगे लेने का. Now we'll talk about what are the remedies you have in case of a breach of a contract. So when a contract is broken, where a contract is broken, the injured party has several courses of action open to him. The appropriate remedy in any case will depend upon the subject matter of the contract and the nature of the breach. So you have a lot of ways कि आप किस way में proceed करना चाहते हो अगर contract में कुछ breach हुआ है और आपके rights कुछ violate हुए हैं. In case of a breach of contract, the injured party जिसके खिलाफ नाइंसाफी हुई है, what the person can do, they can rescind the contract and refuse further performance of the contract. You are feeling कि मेरे conditions जो दिए गए थे वो breach हो रहे हैं, so what you can do कि पूरा contract आप rescind कर रहे हो, cancel कर रहे हो, और मैं और further perform नहीं करूंगा ये बोल रहे हो. Secondly, you can sue for damages. आप कोर्ट जा सकते हो and बोल सकते हो कि मेरा इतना इतना नुकसान हुआ है, I need compensation. Thirdly, you can sue for specific performance, जो कि आप कोर्ट जाके बोल रहे हो कि जो चीज उसने ब्रीच करी है उनको बोलिए that they are legally obligated to do this thing. So that is the specific performance. You're compelling someone to do something so that the contract के terms violate नहीं होता है. Fourth, sue for an injunction to restrain the breach to a negative term. So कुछ एक breach जो होने वाला है बड़ा वाला, आप एक sue कर रहे हो और injunction मतलब उसको block कर रहे हो, right? So you are restraining the breach of a negative term. आप ट्राई कर रहे हो कि वो ब्रीच ना हो, उससे पहले आप इंजंक्शन फाइल कर रहे हो. C1 क्वांटम मेरिट, मतलब इतना इंपॉर्टेंट नहीं है, आपके मेरिट के हिसाब से आप ले रहे हो कोर्ट को एंड देन उन्हें बोल रहे हो कि मेरा ये केस है एंड उनका ये केस है. दैट्स अ होल न्यू थिंग. ऑलराइट, सो नाउ कमिंग टू एन इंटरेस्टिंग पार्ट, विल cover a few doctrines and then cover a few questions. So the first doctrine we are going to talk about is promissory estoppels. उसका मतलब क्या होता है? A person who has made a promise is estopped or prevented from denying the making and enforcement of the promise under stated circumstances. देखो मैंने तुम्हें कोई promise कर लिया है and I am doing something जो कि वो promise को ना कर सके. So what you're trying to do is you are taking upon the help of this doctrine, promissory estoppels, and you're preventing me from denying the making and enforcement of the promise under stated circumstances. So ये courts कब apply करते हैं? In commercial cases where both parties had anticipated that a contract would be formed by mutual promises. दोनों parties को लगा था कि हमारे mutual promises से contract होने वाला है, and उसके बाद कोई एक party अगर ऐसी चीज कर रही है जो कि वो deny कर रही है and they are not trying to avoid it, so the courts can apply this doctrine in commercial cases. Central London's Properties Limited versus High Trees House Limited, ये एक केस था 1947 का. यहाँ पे क्या हुआ था ना, वार चल रहा था, as we all know, Second World War. So Properties Limited वाले बंदे क्या किए थे, they had given a promise that वार के वक्त आप रेंट को थोड़ा कम कर सकते हो. मतलब दिस वाज अ केस ऑफ रिड्यूसिंग द रेंट ड्यूरिंग वार टाइम, हेंस अ प्रॉमिस since a contract already existed to pay a certain amount of rent. देखो कॉन्ट्रैक्ट ऑलरेडी था, कॉन्ट्रैक्ट हाउस और होम मतलब जो रह रहे थे उनके बीच एक कॉन्ट्रैक्ट था which established a fixed amount of rent to be given. But what they did was उस कॉन्ट्रैक्ट के बावजूद they are making a promise personally ऐसे आके कि वार टाइम है तो we are reducing the rent. So when promising to reduce the rent, nothing was given in return, lack of consideration. So technically एक नया कॉन्ट्रैक्ट नहीं बना है. मैंने तुम्हें बोला कि तुम मुझे आज से 100 रुपए कम रेंट दे सकते हो जब तक वार खत्म नहीं होता. दिस डज नॉट मीन कि कॉन्ट्रैक्ट एस्टैब्लिश हुआ हम दोनों के बीच, बिकॉज in exchange for that reduction of rent, I'm not getting anything in return, right? So there is a lack of consideration. जब वार एंड होता है, the rent went to its previous price, जो कॉन्ट्रैक्ट पहले था उस पे चला गया रेंट. The owner ने क्या किया शातिर होके, he or she tried to acquire the full amount of rent for the war time as well. They said कि अब जब वार हुआ था अब तो वार खत्म हो गया है, उस वक्त का भी आप फुल रेंट मुझे दो जो तब आपने रिड्यूस करके दिया था. The court ruled that a promise intended to be binding, intended to be acted on, and in fact acted on, is binding so far its terms properly apply. आपने एक प्रॉमिस दिया था जो आप इंटेंड किए थे बाइंडिंग होने के लिए, जिसको आपने इंटेंड किया था कि मैं हाँ इस प्रॉमिस पे एक्ट करूंगा, एंड इनफैक्ट आपने एक्ट किया भी था, आपने कम रेंट चार्ज किया था. आप वापस आके उसको बदला नहीं सकते बोल के कि कोई मतलब कॉन्ट्रैक्ट था ही नहीं. This is where the doctrine promissory estoppels comes into play. We'll look at another example. A fund was raised for the construction of a temple. Many people promised to contribute, and based on this promise, construction was started. मतलब एक टेम्पल कंस्ट्रक्ट होने वाला था, बहुत सारे लोगों ने प्रॉमिस किया था कि हम इस फंड में कंट्रीब्यूट करेंगे, एंड उन्हीं के प्रॉमिस, उन्हीं के वर्ड्स के बेसिस पे कंस्ट्रक्शन ऑफ द टेम्पल वाज स्टार्टेड. बट लेटर द डिफेंडेंट्स रिफ्यूज्ड टू पे द प्रॉमिस्ड सब्सक्रिप्शन. बाद में उनके अगेंस्ट जब केस हुआ, they became the defendant, the person who files the case is the plaintiff. So here what happens is वो लोग जिन्होंने प्रॉमिस किया था पैसा देने के लिए, they refused to pay this promised subscription. The court in this case allowed the plaintiffs to recover money from the defendants by applying the doctrine of promissory estoppels. The court ने क्या किया, the plaintiffs जिन्होंने फाइल किया था ये केस, अलाउ किया उन्हें कि आप मनी जिन लोगों ने प्रॉमिस किया था उनसे रिकवर कर सकते हो by applying the doctrine of promissory estoppels, because उन्हीं के प्रॉमिस के हिसाब से which was intended to be binding, intended to be acted on, and in fact उन्हीं के basis पे तो construction शुरू भी हो गया था, so it was already acted upon, so this becomes binding. टू एसेंशियल्स आर, ऐसा नहीं है कि आपको हमेशा फोर्स किया जाएगा, एसेंशियल्स दोनों होने चाहिए. देयर मस्ट बी अ प्रॉमिस ऑन पार्ट ऑफ द प्रॉमिसर, जिस प्रॉमिसर को आप स्यू कर रहे हैं कि नहीं ये ऐसा नहीं कर सकते और उनके अगेंस्ट प्रॉमिसरी एस्टोपेल्स अप्लाई करना चाहते हैं, देयर मस्ट बी अ प्रॉमिस ऑन देयर पार्ट. The promise had done something in the promisee had done something in furtherance of such promise. देखो प्रॉमिस किसी ने दिया, आप प्रॉमिसरी हो, आपको प्रॉमिस दिया जा रहा है, मतलब जिसने कंस्ट्रक्शन किया टेंपल का, स्टार्ट कर लिया. सो आपने क्या किया, जो लोग आपको प्रॉमिस कर रहे थे, दे आर द प्रॉमिसर्स, यू आर द प्रॉमिसी. आपने उनके प्रॉमिस के बिहाफ पे, इन फर्दरेंस ऑफ सच प्रॉमिस, यू हैव ऑलरेडी डन समथिंग, यू हैव स्टार्टेड द कंस्ट्रक्शन, राइट? सो दीज आर द टू एसेंशियल्स. The next doctrine we are going to study about is called privity of contract. A stranger to a contract cannot sue both under English and Indian law for want of privity of contract. मतलब दो पार्टीज के बीच में अगर एक कॉन्ट्रैक्ट है तो उस कॉन्ट्रैक्ट के बीच जो इन्वॉल्व नहीं है, a person who is a stranger to such a contract, he or she cannot sue under both Indian and English law. क्यों? Because this doctrine exists which is called privity of contract. उसके लिए we'll study about an illustration. In this case, let me just tell you this quickly. Exam में भी एक लंबे ऐसे केस लिखे होंगे. Try to be faster. Skim through the sections which are not that important for you to remember. Just look at the key points and underline them. If it's your style, or if it slows you down, then that's completely fine as well. So that you do not have to read the whole paragraph again after you have read the question and you want to revert. Okay. So here you're just going to focus on the keywords. D ने X को टायर्स सप्लाई किया. कंडीशन क्या था कि X वो टायर्स जिस भी रिटेलर को रीसप्लाई करेगा, वो रिटेलर प्रॉमिस करेगा X को कि वो टायर्स किसी भी दूसरे लोग को, पब्लिक को नहीं बेचेगा बिलो D's लिस्ट प्राइस. Let me make this clear. D was the person who supplied the tires to a wholesaler X. होलसेलर्स रिटेलर्स को देते हैं, रिटेलर्स फॉर द पब्लिक को बेचते हैं, राइट? सो डी जो सप्लायर है वो होलसेलर से बोल रहा है कि मैं तुम्हें ये दे रहा हूं ऑन द कंडीशन दैट जिस भी रिटेलर को तुम बेचने वाले हो यू शुड टेक अ प्रॉमिस फ्रॉम देम कि वो जो भी पब्लिक को सप्लाई करेंगे मेरे लिस्ट प्राइस के बिलो नहीं जाने वाला, मुझे नुकसान होगा। एक्स ने डी से लिया टायर सप्लायर से, अग्री किया था कंडीशन को, एंड एस को सप्लाई किया। एस जो कि रिटेलर है उसने कंडीशन माना था, बट नेवरदलेस एस सोल्ड द टायर्स बिलो द लिस्ट प्राइस। Held, what was held by the court? There was a contract between D and X and a contract between X and S. Let me make this clear. D is the supplier, X is the wholesaler, and S is the retailer, right? D और X के बीच एक कॉन्ट्रैक्ट था। D और X के बीच क्या कॉन्ट्रैक्ट था कि मैं तुम्हें ये सप्लाई करूंगा एंड के बदले तुम रिटेलर से बोलना कि वो मेरे प्राइस से कम ना बेचे। बट कॉन्ट्रैक्ट X और S के बीच आगे जाते हुए so X ने सप्लाई किया था S को अपॉन दिस कंडीशन दैट कि D के लिस्ट प्राइस से नीचे आप नहीं बेच सकते। So what this said was that there was no contract between D and S as such. Therefore, D was not the person who had the right to sue. All right. So therefore, D could not obtain damages from S as D had not given any consideration for S's promise to X, nor was he party to the contract between D and X. Thus, a person who is not party to a contract cannot sue upon it, even though the contract is for his benefit. चाहे वो D के benefit के लिए ही हुआ हो, but he was not a party to the contract between S and X. उसने प्रॉमिस किया था कि हाँ मैं उस प्राइस के बिलो नहीं बेचूंगा पब्लिक को, वो उसने X को किया था. So D is not the person who can directly sue. For example, देख लो. A who is indebted to B sells his property to C, and C, the purchaser of the property, promises to pay off the debt to B. देखो A B की तरफ indebted है, मतलब A कुछ लोन लिया था B को, so he has to do something in return for him. A क्या करता है, अपनी प्रॉपर्टी को C को बेच लेता है. C जिसने परचेज किया ये प्रॉपर्टी A से प्रॉमिस करता है कि वो A का डेब्ट B को पे कर देगा. Yeah, hello. Sorry for the technical problem. I hope you can hear me. If someone can confirm.
Yeah, you're audible.
Yeah, so I hope I was audible when I was talking about privity of contract.
A little bit, but in the middle of it, your voice started to break.
All right. I'll tell you again about the case. So B kid. So I was talking about the last line. All right. So B has lent out a loan to will pay your debt off to B. But अगर C B को वो debt fail करता है pay करने में, B still has no right to sue C because there is no privity of contract between B and C. Because A O करता है वो loan B को, even though A ने C को बेचा था on this assurance कि C उसका debt B को pay off कर देगा, even if he fails, B has no right to sue. All right. So we have reached the last doctrine of the day, and this involves question as well. So we'll talk about force majeure. What is this doctrine? What does it talk about? We'll delve into this from this paragraph, which seemingly looks a little bit complicated. All right. So this was CLAT 2020, if I'm not mistaken. Everyone, I would like you to pay attention to this. The COVID-19 pandemic has taken the entire world hostage in less than 4 months. As soon as you look at the paragraph starting like this, you know this is nothing related to your legal reasoning. All right. So you can just kind of skim this part and then go ahead directly. Lockdown has caused delays in the performance of contracts and transactions. All right. So now here comes the part which is related to your questions, which will be related to your questions. You can directly start from here. Now, the question that arises is whether the current situation can enable parties to a contract to alter their obligations with non-compliance of terms, neither being regarded as a default committed by any party nor a breach of contract. So ये बोल क्या रहा है कि pandemic हुआ and what it did is that कि lockdown की वजह से contracts and transactions में जो आपने stipulated time period दिया था उसमें बहुत सारे delays होने लगे हैं. Now what the question says is whether the current situation can enable parties to a contract, जो वो parties हैं contract को, क्या वो अपनी obligations को alter कर सकते हैं with non-compliance of terms, neither being regarded as a default by committed by a party or a breach of contract. So वो जो alter करेंगे अपनी obligations को, ऐसा करने वाले हैं कि it should not be something that कि it should classify as a non-compliance of terms, regarded as a breach या फिर default हो गया. वो breach या default को assume ना करके कुछ ऐसे कर सकते हैं, they can just like change this obligation which they have. Right. So there are certain well-accepted practices for dealing with such extraordinary situations in commercial transactions by inclusion of force majeure and material. Yeah.
Ashutosh, I'm sorry, but I can't see your screen being shared, and I think it's the same with other people.
Oh, I'm so sorry. Yeah, I hope it's going to be visible right now. Yeah.
Yeah, now it is.
So sorry. All right. So I'll continue from the starting. So what I was talking to you about is this slide of force majeure. All right. So this is a doctrine which talks about agar aap ek contract mein ho and some extenuating circumstances are such that you need to make some alterations to your terms. But क्या आप वो कर सकते हो without that being regarded as a default या फिर regarded as a breach to a contract, right? So वो कैसे कर सकते हो? The passage talks about COVID-19 pandemic. As we all know, lockdown की वजह से बहुत सारे contracts and transactions में delays हुए होंगे. The question that arises is whether the current situation can enable parties to a contract, जो situation था pandemic के वक्त, will that enable parties to a contract to alter their obligations? मतलब वो जो obligations उनके हैं उसको वो change ऐसे करेंगे with non-compliance of terms, neither being regarded as a default committed nor as a breach of contract. जो वो कर रहे हैं, जो वो term से comply नहीं कर रहे हैं, जो कि पहले किया गया था stipulate, will that not be regarded as a default committed by a party nor a breach of contract? There are certain well-accepted practices for dealing with such extraordinary situations. क्या करते हैं commercial transactions में? What we do is we include force majeure and material adverse effect clauses. What these clauses do is that they will cover some contracts and उसपे वो कुछ ऐसे relaxations देंगे कि अगर ये ऐसा हो गया वो ऐसा हो गया, you will be allowed this lenience. Let's read ahead. The determination of the types of circumstances so covered by the force majeure clause contained in a contract is essential. कौन-कौन से circumstances cover करेंगे ये clause? Let's see. Provisions of force majeure often cover natural disasters like hurricanes, floods, and earthquakes as acts of God. Other covered events may include war, terrorism, civil disorder, fire, disease, medical epidemics, or by reasons of applicable laws and regulations. So, ये क्या करते हैं? They broadly cover such acts which are called acts of God, right? ये पढ़ा भी होगा torts में है शायद. So they such as like hurricane हो गया, flood हो गया, earthquake हो गया. These are something which is not anticipated by the parties to a contract. They happen ऐसे randomly. So they can also cover war, ho gaya, terrorism, and so on. Broadly, the courts have interpreted the term force majeure as an event that can neither be anticipated nor controlled by either of the contracting parties. ऐसा event जो कि आप पहले से predict या फिर पहले से कुछ control नहीं कर सकते. So a force majeure clause applies in the context of ongoing contractual arrangements, whereas a material adverse change clause applies to the allocation of risk in transactions before their closure or completions. So what this says is force majeure clause जो है contractual arrangements आपके अभी चल रहे हैं and in their context you are applying them. MAE material adverse change clauses क्या होते हैं? They are applying जबकि आपका ट्रांजैक्शन स्टार्ट भी नहीं हुआ, मतलब उसके पहले यू आर ऑलरेडी एलोकेटिंग द रिस्क कि ये हुआ तो ये आप उठाओगे, इसका लॉस आप उठाओगे. ऐसे कुछ क्लॉजेस हैं जो कि वी आर एलोकेटिंग द रिस्क इन ट्रांजैक्शंस बिफोर द क्लोजर और कंप्लीशन. Pandemics and related consequences such as government action is a type of event covered by a force majeure clause. However, its impact on the affected party's ability to perform its contractual obligations may vary depending upon contractual terms. It's stating basic obvious things कि हाँ ये सबके लिए समान नहीं होगा, उनके contractual terms के लिए depend करके vary करता है. It is common for force majeure clauses to specify the impact that event or circumstances in question must have in order for the clause to be triggered. मतलब वो क्लॉजेस में यूजुअली स्पेसिफाई कर लिया जाता है कि वो जो इवेंट और सर्कमस्टेंस हुआ है उसका क्या इम्पैक्ट होना चाहिए जिसकी वजह से वो क्लॉज ट्रिगर होगा. References may be made, for example, to the event or circumstances having prevented, hindered, or delayed performance. मतलब ऐसा हो सकता है कि जो भी इवेंट आपके परफॉर्मेंस को हिंडर कर दे रहा है, मतलब ऑब्स्टिकल्स डाल रहा है, डिले किया जा रहा है या फिर उसको प्रिवेंट कर रहा है. So these terms require different levels of impact on performance before a party can claim recourse to these clauses. In other words, the force majeure and material adverse change clauses act as an exception to what would otherwise be treated as a breach of contract. देखो normally जो ये allow कर रहे हैं, that's actually a breach of contract. You are not obeying the terms which you have set for yourselves at the start of a contract. But what they allow is exceptional circumstances में ये trigger हो सकते हैं and they avoid this breach of a contract का mess. Certain contracts may state that if a force majeure clause is applied, the contract may automatically be terminated. On the other hand, some contracts may even state that the duty to fulfill the contractual obligation may be suspended for a certain period of time, and if the force majeure clause is not curbed or treated even after such time, then eventually the contract will be terminated. It's basically narrating कि इस clause के तहत आप क्या क्या कर सकते हो. Either आप ऐसे बोल सकते हो the contract is terminated for both of us, या फिर एक ऐसे मतलब exceptional circumstances की impact की वजह से what you can do is you are suspending the contract for a given period of time, and अगर उसके बाद भी ऐसे circumstances लगे रहे कि you are not able to carry it out, then it will be terminated. Though there cannot be a one-size-fits-all solution to the situation, to this question, and it depends upon how the force majeure clause is worded in a specific contract, and the absence of the same, applicable laws related to the same will be required to take into consideration. अगर वैसा कोई clause नहीं है, then जो बाकी के laws apply होते हैं, they will be taken into consideration. Does anyone have any doubt regarding to the understanding of this passage? It's a fairly theoretical passage, and questions are so as well. So we'll start with the first question. Based on the author's argument in the passage above, which of the following is correct? Force majeure clauses generally have a uniform impact on the performance of contract in all the cases. The impact on the performance of contracts by the uses of force majeure clause is dependent upon the way that such clauses have been constructed in a particular contract. Both these force majeure and material adverse change clauses have similar impact on the performance of contracts, all of the above. So can anyone explain why option B has been stated as the correct answer? Why not option A? Look, what option A basically states is something that's overgeneralizing. It says that force majeure clauses generally have a uniform impact on the performance of contracts in all cases. That's exactly what the opposite of here which was written, right? So it depends upon how the force majeure clause is worded in a specific contract. So their impact varies depending upon the contract to contract, depending upon the contractual terms, their impact. All right. So option A is ruled out. Option C says that force majeure as well as material adverse change both have similar impact. Jabki the passage clearly stated the distinction between both of them. Force majeure is something that comes into play जबकि ongoing contractual agreements हो रहे हैं. MAC is something जो कि contract करने से पहले you are allocating the risk कि अगर ये हुआ you will do this, I'll do that. That's what it is. Force majeure clause is something is being triggered. Next question. I hope option B was correct and everyone understood that. because the impact on the performance of contracts with usage of force majeure clauses, it depends upon the way such clauses have been constructed in a particular contract. Contract to contract basis pe jaake, it depends upon that. So such questions are relatively easy because they do not delve into an issue-based substance. For example, now we'll head to something like A and B involving people, involving cases. Those questions are usually trickier than such theoretical questions. Imagine there is a domestic commercial contract for supply of certain goods for certain price between A and B. All right, so A और B के बीच में contract है, एक दूसरे को कुछ goods supply करने वाले हैं. In pursuance of the same, both A and B forget to negotiate and agree on the terms of a force majeure event, and the contractual document does not contain the force majeure clause. So अभी क्या हुआ कि A और B दोनों भूल गए वैसे कुछ force majeure clause डालने को अपने contract में. So in such a situation, what would be the fate of the contract in the event like that of COVID-19? अगर COVID-19 हुआ ऐसे contract में जिसमें clause नहीं लिखा है, तो वो क्या करेंगे? See, this is something that's coming straight from the last line of the passage. It says that in the absence of the same, applicable laws related to the same will be required to take into consideration. So let's look at the options. As the parties did not negotiate on the force majeure clause, either of them cannot take an exception to the breach of contract. ये ऑप्शन बोल रहा है सिंस उनके पास फोर्स मेजर क्लॉज का कोई नेगोशिएशन नहीं है, दोनों ब्रीच ऑफ कॉन्ट्रैक्ट को एक्सेप्शन बता के नहीं बोल सकते कि हाँ हम ये चेंज कर देंगे. इफ दे डू दैट, दैट विल बी अ ब्रीच ऑफ कॉन्ट्रैक्ट. दैट्स व्हाट द ऑप्शन इज सेइंग. नेक्स्ट ऑप्शन, द पार्टीज कैन इन्वोक द मटेरियल एडवर्स चेंज क्लॉज. Option C, in absence of such clauses in the contract, the courts may resort to the applicable law, that is the Indian Contract Act 1872, to give relief to the parties. D, none of the above. Can anyone explain why the correct option is C? Just try. It's a fairly theoretical question as well. All right, so option B is completely incorrect because there is no mention of an MAC in the question. So this is a question which is meant to, this is our option that's meant to sidetrack you. It's meant to confuse you कि अच्छा MSc तो कर सकते हैं अगर force majeure ना हुआ. But the thing is that there's been no mention of it. How do you know that they have an MSc included in the clause? So that's something that's completely ruled out. Option C rightfully states that अगर वैसा कोई clause नहीं है, the court will resort to the applicable law. कौन सा applicable law? The overarching Indian Contract Act 1872. Look, that is a phrase that has not been mentioned in this passage, but you would have to understand that sometimes such options are included in the exams, which do not exactly come from the passage cited above. So the correct option is C, because the last line states the same. 69. Would anyone like to read the question out? Once you read it yourself, you'll find it involving. Yeah, sure, go ahead.
In the same fact situation as mentioned above, with a modification that there is a force majeure clause in the contract between A and B, let's suppose that B, who was to supply goods to A on a certain date and time, faced issues in relation to procurement of goods due to mill strike and also because of the rise in price of goods. In this case, can B claim the suspension of performance of contract on the basis of force majeure clause?
Yeah. So what this case states is that A और B के बीच एक contract है, and there is also a force majeure clause. मतलब वो जो 68 में था ना कि उनके पास कोई वैसा नहीं था. Now he's saying कि नहीं, थोड़ा सा modification कर लो ऊपर वाला fact situation. They have a contract जिसमें वो clause है. B को supply करना था goods to A on a certain date and time. लेकिन what happened with B is that he faced issues. कौन से issues face किया वो? In relation to procurement of goods due to mill strike, and also because of rise in prices of goods. कोई mill strike हुआ तो वो मतलब strike क्या होता है? एक man-made factor होता है, right? And suddenly उसके goods जो supply करना था उसके prices rise हो गए. So क्या इस case में B claim कर सकता है the suspension of contract on the basis of force majeure clause? Let's look at the options. Yes, B can, depending upon the way the force majeure clause is worded. Such situation cannot be covered under the force majeure clause, as it is a case of disappointed expectations, and hence B cannot invoke the clause. It is merely a case of commercial hardship. C, B can invoke the force majeure clause as the clause is too broad to cover such situations. D, none of the above. Now look, if it's in an exam where you are actually in a hurry, And of course, the correct answer is not something that's been already shown to you. A lot of people will have a knee-jerk reaction, since there is a time limit running, to choose option A, right? Depending upon the force majeure clause ka wording, you will invoke it, because that's what the question says, ki abhi to force majeure clause hai, unlike the question above. But look carefully at the factor. The circumstances that force majeure clause covers, they have been talked about here. So this is an event that can be neither anticipated nor controlled by either of the contracting parties. So a mill strike and goods ke price rise ho jana, and these are natural things which are kind of fairly predictable. Even if you are not expected a mill strike to occur, but like goods ke prices बढ़ गए, that is not a justified explanation to invoke a force majeure clause. For example, you have studied about act of God, या फिर war, terrorism हो गया, civil disorder हो गया, fire हो गया, मतलब वैसे कुछ चीजें होनी चाहिए to invoke this. So option B rightly encapsulates this, as it states that such situations cannot be covered under force majeure because this is a case of disappointed expectations. ये एक commercial hardship का case है. Just because तुम वो goods supply करने वाले थे, उनके prices rise हो गए, तुम afford नहीं कर पाए, that does not mean you will be able to invoke this clause. All right, so we've come to an end of this chapter of law of contracts. I've covered most of the basics, and you start from what a contract is made up of, what are the constituents, what is a proposal, what is an acceptance, a few questions regarding them, how a contract is stated to be valid or not, some contracts which are not valid or void agreements, pre-consent and uske vitiating factors, which is a very interesting and important part, and the question related to it. And we today talked about mistake by questions, special forms of contracts such as agency, contingent contract, and how it's different from a wagering agreement, contract of bailment, how it's different from pledge, indemnity and guarantee. We compared both of them here. And we talked about a few remedies which you have in case of a breach of a contract. We talked about three doctrines. The first one is promissory estoppels, which prevents someone from backing out, to ensure that जो promise तुमने किया था binding करके वो तुम्हें fulfill करना पड़ेगा. Privity of a contract, which means that दो parties के बीच contract है, मतलब third बंदा आके sue नहीं कर सकता. Here we discussed the last concept of the day, force majeure clause. Does anyone have any doubts from today's session?
No.
All right, so perhaps I'll meet you next time, and we'll cover up a new section of the law, and we'll probably move to law of torts. So I hope you enjoyed the session. Have a great time preparing ahead, and yeah, best of luck. Thank you everyone for attending the meeting. You may leave now.
एक जवाब